All right, we're on the record. Record should reflect we are outside the hearing of the jury. Also, that the defendant has waived his presence for the purposes of the charge conference and the record to be made of the charge conference. And so we've had about 2 hours worth of discussion. So I'm not asking counsel to recount the arguments back and forth, but essentially what your positions are.
Right now is tending to some on-the-record proceedings. Let's listen in.
That there is some agreement on some changes that the court will make. The remainder, the court will take under advisement. Mr. Nelson, you want to go first?
Thank you, Your Honor. Your Honor, principally from the defense perspective, in terms of the draft jury instructions, our primary comments, I'm just...
Sorry, I forgot to call it. Hold on. Hi, is this Mr. Iyer?
Yes, hi.
Hi, it's Judge Cahill. We have you on the courtroom speaker now, so we're going to start the record that we're making of the charge conference. Mr. Nelson.
Thank you, Your Honor. Your Honor, as I was saying, the parties had an opportunity. We received a draft copy of the jury instructions from the court, I believe yesterday or the day before. We've had an opportunity to review them. Just briefly to summarize what the defense's concerns were in terms of certain aspects of the jury instructions. I'm not going to summarize every little typo or every agreement that existed because they were largely administrative or just headings and things of that nature. The principal concerns were, first and foremost, the court's proposed instruction with respect to the authorized use of force, Graham versus Connor, and the standards set forth. In that the proposed order or proposed jury instruction did not include reference to the totality of the circumstances. It does not include the recognition of hindsight, the language regarding hindsight, and did not include the language without regard to his own state of mind, intention, or motivation. We addressed all of those. We compared both the standard jury instruction. We compared that with the jury instructions provided in Noor, as well as the state and defense proposed instructions. I would also note that the court, it appeared to the defense that the court, in terms of the inclusion of the 3 principal Graham factors, had omitted 2 of the 3, and I think we've addressed those, and the court is taking some of those matters under consideration. In terms of our second issue, Your Honor, is the defense was requesting a jury instruction pursuant to State versus Whipper, 512 Northwest 2D 92, to inform the jury that Mr. Hall had invoked his Fifth Amendment privileges. Essentially, Your Honor, arguing that therefore, because Mr. Hall had invoked his privilege, he was no longer available to both parties, and had that essentially, because the defense referenced Mr. Hall in the opening statements, and it's an explanation as to why he did not testify, not to infer that he has somehow done anything illegal.
Let me back up just on the use of force instruction, just so the record's clear. I think we all agreed in chambers that the court would abandon its use of force draft and start off of the state's draft with possible language tweaks to that language. Is that your understanding as well?
Agreed, Your Honor, specifically to include the totality of circumstances test, as well as the without in regard to his own state of mind, intention, or motivation language. The hindsight, I know the court has some issues. Again, it was the defense perspective that the hindsight language comes directly from Connor. It's incorporated into the Minneapolis use of force manual, and it was testified to fairly extensively by several witnesses during the course of this case. But yes, I would otherwise agree with the court.
All right. I'm sorry to interrupt you. What's the next one?
The Whipper instruction, but we've discussed
Yep.
that. Your Honor, I had also just administratively requested the instruction relevant to bench conferences. My recollection is the court had instructed the court as to sidebars or bench conferences at the opening of the case. I was just requesting that that be re-included back into the final instructions.
Let me stop you a second again. Regarding the Whipper instruction, you did mention Mr. Hall in opening. Did you mention Ms. Hill in opening?
Yes.
Okay. All right.
As far as the bench conference, I think was just really an administrative issue, and it's a standard jury instruction that I would have asked to be included. There was a significant amount of discussion about superseding cause, the language around superseding cause. I asked the court to continue to use the standard jig as it had been submitted to the parties. The third-degree murder instruction, there was a substantial amount of discussion over the third-degree murder instruction. Again, it would be the defendant's position that the court's instruction is consistent with the Supreme Court's most recent ruling in the Coleman case, as well as the statutory language, and we are requesting that it remain as such.
And Coleman specifically stated that the jury instruction guide, the JIG, was not an accurate reflection of law, and that's why this is a departure and a new instruction.
Agreed, Your Honor.
Okay.
With respect to, some of the defense in objections, I would note that in terms of the second-degree murder case, perhaps the bulk of our discussion had to do with the intent language, in the intent specifically as referenced or with reference to the underlying third-degree assault. And there was a lot of back and forth about that. Again, it is the defendant's position that the standard jury instruction should be applied as the court had included, and that modifications were not necessary relevant to intent to cause the assault, that discussion, just paraphrasing. The defense objected to inclusion of the accomplice liability.
And just so the record's clear, the court's original draft excluded Crim Jig 4.01 accessory liability, but added in the elements that the defendant acting alone or assisted by others, and the state had some concerns about that they can speak to, but that I did indicate that we are going to put in some form of 4.01 back. If the court puts it back, it's my understanding, Mr. Nelson, that you are agreeable with having it only once as opposed to once after each charge. Is that correct?
Correct, because again, Your Honor, the defendant's position in that regard was if accomplice liability was going to be included as to each potential charge, then so too should the Graham versus Connor standard be. And for ease of purposes, it should be ease of understanding the instructions, I should say. If the court is going to put that back in, it should be in a single place, and then it should be removed from the definitions. There was that whole discussion of how many times, where is it going to be.
Correct.
So yes, if the court is going to put it in, it should be in a single place.
All right.
Similar to how the court has dealt with the other definitions and defenses. The last thing that I had noted, at least just quickly, the state had made a request relevant to the duties of judge and jury, asking the court to include the standard jury instruction relevant to the jury not being considerate of punishment. The court indicated that it, and I noted that it did also include that language, but at a later part in the instructions. I would ask that it simply be included once, whether it be at the front or the back side of the instructions. It's an appropriate instruction. It's a part of the standard jury instruction guides, and I would submit to the court that it should just simply be included once at the risk of highlighting this.
Well, just for the record, I long ago changed it. I think it's in 3.02. Usually in the standard jury instruction guide, I pulled it out of that and put it in the end where the court discusses what the jury should not consider, specifically sympathy, prejudice, bias, public opinion, and they should also not consider the consequences or possible penalties that might attach to their decision. And I put in consequence, which I think the JIC does not have, because by saying don't worry about potential penalties that might attach to your decisions is implying that the court believes a guilty verdict is going to come back, and I don't think that's appropriate. But
I agree.
I understand your position on this.
I agree with how the court has it constructed right now is appropriate. So the inclusion of it at the beginning in terms of the roles and duties of the judge and the jury, number one, I think it's duplicative. Number two, I think it's appropriately placed within the context of these instructions in the list of things that the jury should not consider.
All right.
And I agree with the change of the word consequence.
All right. And I would note that you did file proposed jury instructions, and as I said when your client was present, I consider that a motion to include, and if the court fails to include it, that's essentially denying your motion, and that preserves the issue for appeal.
Precisely, Your Honor, and that's why we didn't end up talking a lot about a lot of the either side's instructions.
All right. Thank you. Mr. Frank, you going to address it?
I think Mr. Iyer will summarize first, Your Honor.
All right, Mr. Iyer, if you could, you're appearing by phone. If you could summarize the positions.
Thank you, Your Honor. I have 8 points that I'll quickly run through, and Mr. Frank can supplement anything that I've missed.
All right.
First, the state requested an aiding and abetting instruction and instruction on accomplice liability under CrimJig 4.01. We provided notice of this theory of liability back in February when the state filed its initial draft jury instructions. And the Minnesota Supreme Court said in State v. Giverny, it's 592 Northwest 837, that the state can add an additional accomplice theory of liability to the jury instructions without amending the complaint and at any time prior to verdict. And with respect to the charges in this case, the evidence shows that Mr. King's actions were also potentially a substantial causal factor. The pressure on his back, on Mr. Floyd's back, may have resulted in positional asphyxia, causing Mr. Floyd's death. And the testimony of Dr. Tobin, Dr. Smock, provides powerful evidence of that. So we think the evidence readily supports submitting this accomplice theory of liability to the jury with respect to Mr. Chauvin, and we respectfully requested that instruction. I'd also note that the state believes that that language from CrimJig 4.01 should be given in conjunction with the acting alone or aided by others language that Your Honor referenced that appears in the causation element of each charge in the draft of the jury instruction.
Although, to be fair, that's not contained in the jury instruction guide. That was my addition. And I did advise counsel that it's probably going to be one or the other, either just that phrase or the 4.01. I think we all agreed that 4.01 is probably more appropriate. I'll see about leaving it in there, but just so that I think we're all on the same page as far as 4.01. And would you agree that 4.01 jury instruction guide regarding accomplice liability should be given only once for clarity?
Yes, the state has no objection to giving that accomplice liability instruction only once after all of the charges are first laid out for the jury.
All right. Okay.
Second, we'd asked for a revised definition of assault, which of course relates to the second-degree murder charge. As written, the state believes that the instructions suggest that the defendant must have a purpose to inflict or cause bodily harm in order for the defendant's conduct to constitute an assault. That would be legally incorrect, and in fact, that was the very argument the Minnesota Supreme Court rejected in Dorn. The Minnesota Supreme Court held in Dorn, which is at 887 Northwest 2nd, 826, and Fleck, which is 810 Northwest 2nd, 303, that assault, quote, only requires proof that the defendant intended to do the physical act, quote, of committing a battery, without proof that he meant to or knew that he would violate the law or cause a particular result. In other words, the state doesn't need to show that the defendant had an intent to cause bodily harm. And we therefore requested that the court clarify the definition of assault by adding the following two sentences to its definition of assault. I'll read them for the record. Quote, the intentional infliction of bodily harm requires proof that the defendant intentionally applied force to another person without that person's consent, and that this act resulted in bodily harm. It does not require proof that the defendant intended to cause bodily harm or that the defendant knew that his actions would cause bodily harm. And that language is drawn largely from Supreme Court's decisions in Dorn and Fleck.
Before you go on, I just wanted to clarify the state's position regarding, in the definitional section, the court defined assault as either assault harm, intentional infliction of bodily harm, or intent to create fear of imminent bodily harm. Is it the state's preference that I exclude the second alternative, essentially the assault fear definition?
Your Honor, I believe the court's definition of assault did not include assault fear. It only included assault harm. It said assault is the intentional infliction of bodily harm upon another or the attempt to inflict bodily harm upon another. So while the state believes that if assault fear were implicated, then there would be a different intent standard. Here, this is an assault harm case, and so assault harm is a general intent crime.
All right, just wanted to clarify that. Thank you. Next point.
Thank you, Your Honor. Third, the state raised an issue with respect to the definition of superseding cause in the instructions. The state proposed adding a sentence on superseding cause based on Your Honor's probable cause order on page 45 of that order, and State v. Olson, which is at 435 Northwest 2nd, 530. It's a 1989 Minnesota Supreme Court case. And the state requested the language, quote, to qualify as a superseding cause, the intervening conduct must be the sole cause of death. And it's my understanding that the court is taking that issue under advisement.
Correct.
Fourth, the state recommended the deletion or the modification of the definition of reckless disregard in light of the Supreme Court's decision in State v. Coleman. Coleman held that third-degree murder has a mental state requirement of reckless disregard of human life, but distinguished that from the recklessness required for a manslaughter offense. We therefore recommend deleting the definition that was provided. Reckless disregard means to act with a conscious disregard of a substantial and unjustifiable risk. That was the initial draft language that the court provided, and we recommended either deleting that language or, in the alternative, defining reckless disregard as follows. Reckless disregard for human life means that the defendant was indifferent to the loss of life that an eminently dangerous act by the defendant could cause.
And that's drawn from Coleman, your reading of Coleman?
Yes, that language is taken basically word for word from the Supreme Court's decision in Coleman.
All right. That's under advisement.
Fifth, sorry, Your Honor.
Oh, go ahead.
Okay. Fifth, the court, the state addressed a statement on page 5 of the draft instructions, specifically with respect to the third element of second-degree murder. The statement in the instructions was, quote, it is not necessary for the state to prove the defendant intended to inflict substantial bodily harm, only that the defendant intended to commit the assault. The state believes that this is an incorrect statement of the law under Dorn, the Minnesota Supreme Court's decision. In Dorn, the Court of Appeals had held that assault requires an intent to commit a battery. The Minnesota Supreme Court disagreed with that, rejected that interpretation, and said the mens rea requirement for assault is not that, quote, the defendant must intend to commit a battery. Rather, the defendant need only intend to commit an act that constitutes a battery. And the Supreme Court said that that distinction was important because the intent to commit language suggests that a defendant wouldn't just need to know the facts that make conduct illegal, but would also need to know that his or her conduct broke the law. And so we propose modifying this language by using language directly from the Minnesota Supreme Court's decision in Dorn. I'll read it for the record. Quote, "It is not necessary for the state to prove that the defendant intended to inflict substantial bodily harm, only that the defendant intentionally applied force to another person without his consent." And again, that comes from Dorn, 887 Northwest 2nd at 831.
And the Dorn language is not currently in the jury instruction guide for murder in the second degree, is that correct? Or assault 3? Am I correct on that? All right. Okay, next.
6, the state addressed the statement on page 6 of the draft instructions, and specifically with respect to the third element of the third-degree murder statute. It's repeated twice in that third element, that the act must be, quote, "eminently dangerous to other persons." Our objection stemmed from the use of the word persons there, as that instruction could confuse and potentially mislead the jury as to the applicable law in light of the Minnesota Court of Appeals' decision in Knorr. Specifically, that is the instruction the court provided, the draft instruction, might suggest to the jury that this element is satisfied only if the act is eminently dangerous to multiple other persons. But in Knorr, the Court of Appeals held that the third-degree murder statute, the reference to perpetration of an eminently dangerous act to others doesn't preclude its application when the death-causing act endangered only a single person. And so to address the problem, the state asked the court to change the language "eminently dangerous to other persons" to, quote, "eminently dangerous to another." 7th, the state raised an issue with respect to the fourth element of third-degree murder, as was on page 6 of the draft jury instruction, and asked the court to delete the phrase, quote, "may not have been specifically directed at the particular person whose death occurred," unquote. And that clause, the state believes, is likely to be confusing to the jury, that may not, the word may not, can be interpreted in two different ways. It can be interpreted as need not have been specifically directed, or it could be interpreted as cannot have been specifically directed. And the former interpretation would be consistent with Knorr, but the latter would not be.
So need to. You would prefer need to as opposed to may have, or may not have been.
I think, Your Honor, we would prefer that the clause that I pointed to may not have been specifically directed at the particular person whose death occurred be struck, but in the alternative, the court could change may not to need not.
Okay. So your first position is strike the phrase. If not striking the phrase, then change may to need.
Yes.
Okay.
Correct.
All right. Thank you.
Thank you, Your Honor. And then the last issue, which Mr. Nelson raised, is that and adverted to, is that the state asked the court to add a warning against the jury considering punishments during the guilt phase at the beginning of the instructions. As Mr. Nelson mentioned, the CrimJig 3.01 includes within a paragraph on the fact that the jury may not consider possible penalties. And the state asked that this instruction be given to the jury up front rather than at the very end of or near the very end of the instructions. And at a minimum, the state requested that the language in CrimJig 3.01 be provided to the jury at some point in the instructions, even if it is towards the end of the instruction.
All right. Anything else from the state? Ms. Frank, you have some additional points?
I may, Your Honor, just briefly.
If you would.
We had, Your Honor, I think we had also addressed just a couple of minor factors that are more typos that I won't go into, but we did talk about editing some language out of the prior incident
Yes.
instructions to leave just the instruction as the court had previously given the jurors about the May 2019 incident, to just give that as the court had previously given it.
And that's going to happen.
Okay. We also discussed not including the instruction about essentially what is the circumstantial evidence standard of review. We opposed that instruction, or any instruction of that type.
Yeah, as long as we're on the record, I wanted to make it clear that I've already decided that, and I'm not not granting the defense motion to include the, reasonable, rational inferences, that if there are alternatives, they have to choose the one consistent with innocence. That is a standard on appeal, and even on appeal, it's my understanding of the law that it applies only when an element of the crime is proven solely by circumstantial evidence, and I think it is appropriate that the defense can argue, if they narrowly tailor their argument, that intent, for example, is proven solely by circumstantial evidence. There is no such thing as direct evidence of intent, but it's inferred from person's actions and words, and they can argue that as part of the presumption of innocence if you have two reasonable alternatives. That, just to give the state a heads up, that even though I'm not giving the instruction, such an argument would be consistent with law and I would overrule an objection. If the defense, just as broadly, if there are two rational inferences, one consistent with innocence, one consistent with guilt, that is not an accurate statement, and I would sustain an objection to a summary of law that does not include the words solely proven by circumstantial evidence. So just so that we're clear on that.
Yeah, I think the word solely there is critical to based on the current state of the law. I also think it's, for counsel to argue that if you have a rational hypothesis other than guilt, that could be seen as reasonable doubt. I think that's an argument that can be made. It's saying that you must, I think, would be inappropriate. Your Honor, we did oppose the instruction about the invocation of the Fifth Amendment privilege, just so that's on the record. And, Your Honor, we had asked the court to sort of restructure the definition of intentional. The 60902 definition has some slightly different formulations of definitions for things like intentionally, with intent to, and intent that. So we asked the court to break those out specifically, and also because then later the assault definition, the elements, has this altered definition for assault harm crimes that ties into that argument as well about this general intent crime of assault harm.
And Ms. Eldridge explained it pretty thoroughly that we are going to do that, break those apart a bit, but make them consistent with statutory language and consistent with the elements.
And Your Honor, I think that is all I wanted to make a record of. Thank you.
Mr. Nelson.
Your Honor, the only other thing relevant to the state's definition of the reasonable use of force was we had discussed removing the last sentence of the second to the last paragraph that states whether the officer's own conduct during the incident unreasonably created the need to use such force. And we had objected to that, and I think the state, correct me if I'm wrong, was okay removing that.
All right. All right, I think we've made a record of pretty much what the different positions were. Some I've indicated what we are going to do. Some, the rest are going to be under advisement. Mr. Schaefer and I will put our heads together, come up with a draft to hopefully get it to you tonight, but let me promise by 9 o'clock tomorrow morning so that you aren't waiting up till midnight and we've not been able to get it to you. We want to make it right, obviously. So, but we understand you're all sort of preparing closings, and so you'd like to know what the instructions are. So we will act with all haste that we may do so. Get you out a good draft. Keep in mind, when you respond to the draft, it's strictly about typos. We're not going to re-argue the substance. Okay? All right. Thank you. See you at 9 o'clock Monday.
And the court right now wrapping up some on-the-record proceedings in the trial of Derek Chauvin. You just heard the judge say on Monday, closing arguments are expected to begin first thing Monday morning. In the meantime, we will have much more on all of today's developments starting today at 4:30.